Petition and the fact that it could also be reviewed, and the fact that this is not static, it's dynamic, and things could be reviewed if at all there is a need for it. In fact, it turns out that in all likelihood the review petition is going to be filed in the Supreme Court of India. That's the latest coming in. This is the big development on the Aravalli review matter that's going to take place. We are being told, sources are indicating that several groups are now basically coming together. They have already raised questions about the judgment that was passed, where they've raised concerns about the judgment of the Supreme Court of India. The author of it happens to be the former Chief Justice of India, stating that following the revision of the definition of Aravalli, large part of the landforms aren't really protected because of the definition that has been reviewed by the Supreme Court of India. In fact, the former Chief Justice of India, Justice Gavai, essentially defended his entire position on this matter, particularly with regards to the slope definition of the Aravalli, saying that this was done keeping in mind the recommendations that have essentially come in from a committee that was set up by the Environment Ministry, and this was done to prevent further mining to be carried out in the areas in the Aravalli ranges, saying that 90%. Now, the Environment Minister had said 90% of the Aravallis would be protected. Let me also go across to our legal editor, Rhythm, who's joining us on this broadcast. A massive Republic impact coming in, an indication that we've had through the day, Rhythm, about a review petition likely to be filed in the Supreme Court of India. What more do you have?
Well, that's right. We have been seeing that this entire case of the Aravalli needs to be protected, Shravan. And we have been looking at what this 100-meter ruling means. Yesterday, we were the only channel to have the former Chief Justice of India, Justice Gavai, who explained in great detail what his 29-page judgment was. A political and environmental storm has been created after the new definition to the Aravalli ranges and our Aravalli hills has come out. We're now being told, sources tell us, it's likely that once the Supreme Court reopens, there will be a review petition that's likely to be filed in the top court of the country on the 20th November judgment of the Supreme Court of India. This is a judgment that has, in a sense, changed the definition of what comprises the Aravalli. On the basis of this, there will be a review. The environmentalists on the channel speak about the 100-meter rule. The Supreme Court had said they want to establish a uniform definition for Aravalli hills and ranges. It was aimed, according to the former Chief Justice, to regulate mining activities. However, several people who've been looking at the Supreme Court ruling have stated that the Supreme Court ruling, in a sense, has backfired. It has triggered protests across the 4 states in which they will be coming across. And the main reason for this is because it is weakening the environment. It is not strengthening the environment. There have been protests and political criticism over the so-called 100-meter rule and the landforms that are covered under the new definition. The review petition to be likely to be filed in January in the top court.
Rhythm, there has been a major debate on the definition itself, but the former Chief Justice of India, Justice Gavai, defended by stating that this was also based on a committee that was formed by the Environment Ministry, and this was essentially done to protect the Aravalli ranges. 90% of it would have been protected, is what they said, and also, more importantly, that mining activities would have essentially reduced. What is it that you're picking up from the groups that are likely to move the court for a review petition on this?
They are against the new definition that has been given. There are several reasons that are there and why the Aravalli needs to be protected. The one reason for this definition that is not being looked at is that the mining risks are there and the violations will continue. The second thing that has been said by the people who are flagging the environmental concerns is simple. They're saying that mining will not only continue, but even this new committee has not looked at, has overlooked the 2012 FSI definition that was to be followed. In fact, in paragraph 27, 28 and 30 of the 29-page judgment, the amicus curiae, who is the friend of the court, Mr. K. Parmeshwar, senior advocate, had said that the judgment should also have taken into view the FSI's view, otherwise there would be environmental concerns. But that view, according to these people going to be filing the review, has been overlooked by the top court.
You're saying that, this entire aspect of the amicus curiae particularly coming into this picture, weighing into what was essentially seen as perhaps redefining the Aravalli ranges itself. Now, some argument that has been made by the Environment Ministry with regards to mining, saying that mining actually was happening at a much larger scale in the past. With this new definition, they would have been able to protect large tracts, large landforms, part of the Aravalli ranges. What is it that you are getting to know from those who are arguing that that's not the case?
Niranjan, I beg your pardon. Shravan, in fact, I was earlier speaking to my colleague, so that's why the slip of tongue. But coming back to this case, there has been a complete protest because this definition, the new definition, it says only those over 100 meters above local terrain qualify as protected. Therefore, anything below that 100 meters is not protected. Therefore, there is an increased risk of mining, of desertification, groundwater loss in Rajasthan, Haryana and Delhi. Shravan, you have been getting our colleagues to go and do these reports in all these states, and it's very, very clear that the court did not apply what is called the precautionary principle. There is important to have sustained development, but at what cost? Today it's the Aravalli Hills. It's important to remember that these are Aravalli Hills that have been there for centuries. Tomorrow it will be opening up the Western Ghats of the Himalayas is the argument that is being given by the environmentalists. They're also very clearly saying that when it came earlier, illegal mining was there. Even today when the environmentalists are coming, even in the protected zones, there is continued mining that's there. So the Supreme Court's acceptance of the centre's definition, which states any hill in the range with an elevation of less than 100 meters are not subject to restrictions against mining, is going to be subject to review. The top court had accepted the recommendation for sustainable mining in the Aravalli Hills and steps to be taken for preventing illegal mining. But the fact that sustainable mining has been accepted and the fact that any hills in the range with an elevation of less than 100 meters is not subject to strictures against mining had been accepted is what has been the basic crux of the arguments of the environmentalists, and that's why this review is going to be filed, where they say the Aravalli range, which is under serious threat after the Supreme Court ruling that limits its definition to hills rising 100 meters above the local terrain, potentially stripping protection from nearly 90% of the Aravallis across Delhi, NCR, Rajasthan, Haryana, leaves them exposed to mining, deforestation, and also excavation.
Rhythm, just one final question before I let you go, because this is a massive development just taking place just a day after Editor-in-Chief Arnab Goswami had a rare direct conversation with the former Chief Justice of India, the author of this entire judgment. Now, following which, within the legal circles also, Rhythm, there has been a growing clamor, and that essentially being of the fact that whether at all this was done in a tearing hurry to begin with. What's the sense that you've got, because you've been speaking to a cross-section of people over the last few days, particularly those who have been part of multiple petitions that have been filed in the court. Former Chief Justice says that this has been done over a period of time, and the fact that multiple hearings have actually taken place.
Well, there have been protests, but the government needed to clarify if the judgment was really in the best interest of the people and was it against mining. This is a billion years old ancient Aravalli mountain range, Shravan. Nature could not swallow this in thousands of years. We should be preventing Delhi, Rajasthan, Western India from turning into a desert. In this rare and viral former Chief Justice of India's interview to Arnab, it was very clear when he stated that this Aravalli redefinition judgment could possibly be reviewed. In fact, he had also given a hint that there could be a possible review of this judgment, and the basic reason is because the Aravalli revival and groundwater recharge has to be prioritized. There needs to be a priority and precautionary principle followed when it comes to court-mandated safeguards and scientific monitoring needs to be there. Aravallis need to be protected and strengthened and secured.
Well, thank you very much, Rhythm, for putting this into perspective. Now, it all happened after this rare and direct conversation, which is actually at the heart of one of India's most consequential verdicts. Justice B.R. Gavai, the former Chief Justice of India who authored